Life after a 72-hour hold. Navigating the impact and your rights. The Baker Act. A confidential medical process, but what happens next? A 72-hour hold under the Baker Act can be a life-altering experience, but what happens once it's over? This is where the real journey begins, and it's crucial to understand your rights and the potential challenges ahead. Confidentiality and privacy. The Baker Act evaluation is a private matter, not a criminal one. It's essential to know that your medical records are protected by law. Florida law and HIPAA ensure your evaluation remains confidential. Employment concerns. Employers cannot fire you solely due to a mental health condition, thanks to the ADA. But here's where it gets tricky. How does this play out in reality? Can your employer find out about your hold, and what are the potential consequences? The truth about discharge. The moment you're admitted, we start planning your discharge, says Tanya Dix. This proactive approach ensures a seamless transition to outpatient care, with resources and support systems in place. But what does this mean for you? It's about having a clear plan for your recovery, including medications, coping strategies, and follow-up care. Post-discharge steps. Review your discharge papers and make those follow-up appointments. It's time to take control of your recovery and seek support from loved ones. Medical privacy. Who's in the know? Your employer can't access your records without your consent or a court order. But what constitutes good cause for a judge to grant access? This is a crucial question for those concerned about privacy. Court records. What's public and what's not? Baker Act case files are exempt from public records, but limited information may still appear online. And this is the part most people miss. Judges can issue administrative orders to further restrict online visibility. Job security and disclosure. You're not obligated to tell your employer about your Baker Act hold. But what if you need accommodations? The ADA protects employees from discrimination, but it's a delicate balance. And what about those workplace rules and job performance expectations? Background checks. Uncovering the hidden truths. The Baker Act won't show up on standard criminal background checks, but it might appear on specialized checks for specific professions. And this is where it gets controversial. Certain professions may inquire about mental health history, including involuntary holds. Could this impact your career prospects? Firearms and concealed carry, navigating the legal landscape. A 72-hour evaluation doesn't automatically restrict firearm ownership. However, court-ordered commitments are reported to databases that can block gun purchases. But why is there a higher reporting threshold for initial examinations? As you navigate life after a Baker Act hold, understanding your rights and the potential challenges is key. But what do you think? Are these protections enough, or is there more to be done to support individuals in their recovery? Share your thoughts and experiences in the comments below, and let's explore this complex issue together.